Hi, this is Lisa DeMonte with mylegal.com. We're here in Washington, D.C. on Friday, May the 7th for the second annual National Institute on Internal Corporate Investigations and Forum for In-House Counsel. With me this afternoon is Jack Cinquegrana, who is a partner at Choate, Hall & Stewart in the Government Enforcement Division, and also Bill Schreiner, who's a partner at Zuckerman Spader's D.C. office in insurance law. Welcome, gentlemen. Thanks for joining me this afternoon.
Thanks for having me.
Gentlemen, both of you were part of a panel this afternoon discussing current issues impacting directors' and officers' insurance coverage. There were many interesting topics discussed this afternoon, such as when does coverage kick in, strategic uses of settlements, issues surrounding potential bankruptcy. An audience participant asked a very interesting question, and that was how making an insurance claim impacts the company's obligation regarding self-reporting to the SEC. I'd like for both of you to comment on your thoughts on that topic. Jack?
Well, it was a great question. We talked about the obligation to give notice to an insurer under a policy of any circumstance which might give rise to coverage. Then we talked about, well, what are the obligations of a public company when an event happens which might be deemed material under the securities laws? You might at first say, well, the threshold for a notice of claim might be lower than the threshold for having to make a material disclosure. But that said, as one of our colleagues pointed out, you don't want to be in a position where you've told an insurance company something you haven't told your investors. And so it was a really good question, which we had a lot of good conversation about.
Thanks, Jack. Bill?
For me, what it pointed out was how important it is for the insurance recovery lawyers, the white-collar lawyers, the in-house counsel, the government enforcement lawyers, to be on the same page early on. And all of them to be communicating as often as they can from their individual angles so that you're not crossing lines, you're not doing something, the insurance lawyers and saying something that the government enforcement lawyers saying, oh my God, what are you doing? This is going to throw everything off track. So that the whole investigation, claim, whatever you had, is handled in one way with respect to all of the fronts that the company faces.
Gentlemen, thanks very much for your insight. The ABA has lots of excellent material that you and others have prepared, so we'll have a link for that so that others can access that material. Again, thanks for your input. Have a great afternoon. That's it.
That's neat.
All right.
That's it. Okay. So I'll send you.
You're going to send this to me.
I will. I'll send
And
you
you.
both the
Okay.
link.
All right, give us your card. We never did.